Dear learners, welcome back to your educational channel, Learn and Educate, where we were studying a few basics about the Companies Act, under which today we would study small company. Small company as per Section 2, Clause 85, wherein the old prescribed limits have been amended with for the purpose of increasing. The objective behind this was to exceed the limit for the purpose of small company, to make it simple and easy to understand, and for the purpose of removal of restrictions and compliance. As per the company's specification of definition details amendment rules 2002, the revised definition of a small company has been introduced, particularly with respect to the threshold limits for paid up share capital and threshold limits for the turnover. As per Section 2, Clause 85, small company. Small company means a company other than a public company. The public company, as per the Companies Act 2013, which means all the company which is not a private company. A public company, as per Section 2, Clause 71 of the Companies Act 2013, it means a company which is not a private company, and that company, a company which is a subsidiary of a company which is not a private company, then that subsidiary company shall be deemed to be a public company for the purpose of the Companies Act, even though such subsidiary company it continues to be a private company in its articles. Therefore, as per a private as per the public company definition, a public company means a company which is not a private company. Then in the same manner, the private company has been defined under Section 2, Clause 68 as a company as per its articles of association of private limited company. It restricts the transfer of its shares. A private limited company restricts the transfer of its shares, and except in the case of one person company, the articles of association of a private limited company limits the number of its members to 200. That is, the maximum number of limit of a private limited company is 200, and it restricts the transfer of its shares. But in the case of the public company, its main feature is the transferability of its shares. The transfer of shares between the persons takes place, and therefore a public company is a company which is not a private company, and it allows, as per its articles of association, the transferability of shares, and there is no maximum limit on the number of persons who can become the member of a public company. Now, returning back to Section 2, Clause 85, we have understood about the public company, and for the purpose of small company, the small company has its minimum paid up share capital, minimum prescribed limit for the paid up capital is been exceeded, and paid up share capital of which does not exceed 4 crore rupees. The new threshold limit for the paid up share capital shall not exceed 4 crore rupees, and the turnover as per its last profit and loss account does not exceed 40 crore rupees. This is amended as per the company's specification of definition details amendment rules 2022, and it has been made with the objective for the purpose of revision, which is aimed so as to expansion of the business operations and simplification of business operations, to reduce the compliance burdens for the small entities, and moreover the small companies which do business. For that purpose, the structure of the business of a small company which has been classified as a company whose does not qualify for that purpose, but the small companies limit which has been broadened so that more and more companies could be considered, could come under its ambit. It would reduce their compliance burdens, and the redefined parameter for the purpose of classification of the companies under the Companies Act 2013, so as that more companies, more smaller companies would come under its counterpart, and a wide range of smaller entities which would get the environmental benefit for their growth and sustainability. This amendment made would enable the strategic effort to include a wide range of smaller entities, a wide range of small companies, and provided that as per this clause, nothing shall apply to a holding company or a subsidiary company. We have already understood that a company which has been registered under Section 8 of the Companies Act 2013, which has been made for the purpose of promoting a company whose main purpose is to promote the arts, whose main purpose is to promote the other than the this objective is for the charitable purpose. It intends that companies, as per its object, its purpose is to promotion of commerce, arts, science, sports, education in the field of research, social welfare, religion, charity, protection of environment, or any other objects, and any purpose, any association of purpose which propose to register under the act as a limited company, and it intends to apply its profits, incomes earned by it for the purpose of promotion of its objects, and its object is for the promotion of art, sports, education, research, social welfare, protection of environment, any other objects which prohibits the payment of any dividend to its members. This a company which has been formed, registered under Section 8, it restricts the payment of dividend to its members, and any other company which has been formed, body corporate, formed under any special act of parliament, under any special act of state legislature assembly, which shall not be considered as a small company as per section 2 clause 85 of the Companies Act 2013. Small companies are those companies whose paid up share capital does not exceed 4 crore rupees or more, and the turnover of it as per the last profit and loss account does not exceed 40 crore rupees.